Hey, all right, so my name is Dustin Ingram. This talk is called Data Protection for Developers. First things first, I have a few disclaimers, all right? Hope that's scary enough. The first thing is, I'm a developer advocate. I am not a lawyer. This might be confusing to you if you speak another language. Advocate, lawyer are often the same thing, but I'm not. So don't take anything I'm about to say as legal advice or policy advice. I also work for Google. This talk is not about Google, so I'm not promising that our products are GDPR compliant or that they provide like a GDPR fix or like a silver bullet, because they definitely don't. The last thing is, I love Python. I'm one of the maintainers of the Python package index. I organize PyCascades. I've given a ton of talks about Python. This is not a talk about Python. This is a talk about my interests at an intersection of technology and law, and it's about something that's kind of been building up for a really long time. And it's kind of coming to a head now, but not a whole lot of people know about it. And that thing is data protection. So first, before I start talking about data protection, I want to just talk about data. Like, what is data? We're talking about big data, small data, medium data. Generally, a data is just like a collection of values for one or more variables. It's discrete pieces of information. It comes from the Latin root datum, and this is kind of important. It means, it comes from datum, which means something that is given. So, for example, let's say I invite you all to a pizza party, and at the party I start counting how many pizzas we all eat at the end. You might be like, okay, that makes sense. But what if I was counting like the individual number of pieces of pizza that each of you were eating? You might be like, that's kind of creepy and weird, Dustin, why would you do that? And there's also kind of an ethical issue here. Like, is that data given to me, or am I taking it from you? And whose data was it, really, right? So some people that work in data protection like to use the word capta instead to describe this kind of data that is taken. And capta comes from the capere, which is same root as capture and captive. And you might have also heard of personally identifiable information. So this is another type of data that's really specific to one person that can be used to identify that person or just simply belongs to a single person. So for the purposes of this talk, I'm just going to be talking about personal data, any data that is about you or that you generate, both data and capta. And we're going to start in Germany. Germany might not be the first place that you think of when I'm talking about the birthplace of data protection. But Germany was kind of an interesting place right after World War II. It's kind of like Twitter these days. Many citizens were having a really strong reaction to their previous government. They wanted to ensure that a potential dictator never again had the chance to come to power in their country. But you can't just pass a law that says no Hitlers. But what you can do is pass laws that prohibit the things that give Nazis power and which make the things that Nazis like to do illegal. So in 1949, Germany got the Basic Law, and this had two key tenets. First, a person's dignity is inviolable under all circumstances. And second, each person has the right to develop their personality, as long as it doesn't injure or interfere with the rights of others. So personality is kind of a funny word here. In German, it's actually this, which I'm not going to try to pronounce, but it basically means rights of the personality, or the right to be yourself and do things that you want to do. So there were some other concerns that Germans had increasingly in the 50s and 60s. So one was nuclear power, kind of scary nuclear power. Second was pollution, a lot like we are today. And the third was data privacy. And all three of these have something in common. They all concern the same thing, the acceptable use of some new technological development, right? Each of these things has so many complex and interconnected parts that one individual cannot possibly grasp all of the issues involved. And for data protection specifically, this comes from two places. One, the Germans saw the increasing use of computers, and two, their history, right? As a nation, how did the Nazis know who were Jewish? They looked at census records, tax returns, synagogue membership lists. All of these were seemingly harmless data that their government had collected on them. So in 1979, one of the states in Germany, Hesse, passed a law called the Hessian Data Protection Act. And this was more legislation on top of the Basic Law. And the name is kind of a misnomer. It didn't actually protect data. It protected the people whose data was being processed. And it was only concerned with data ex ante, data, what was done with the data after it was collected. It wasn't really concerned with how data was collected or who was collecting it. And it was only really focused also in the public sector. So the processing of data in the public sector. The interesting thing this law did was it created someone called the Data Protection Commissioner. So this is a person that was charged with overseeing any violations of this Data Protection Act. And kind of ironically, this first commissioner was actually kind of a dictator himself. He held the post for 16 years. But this is considered to be the very first Data Protection Act ever. And this was 1970. This law might seem kind of primitive. It was only focused on the uses of data, nothing about encryption or breaches or anything like that. But this, the Enigma machine, was the best that we had in terms of encryption at the end of World War II. And it wasn't even until 1975 that we had our first encryption standard. So this is actually pretty good. Like, this is really progressive. Around the same time in Sweden, they had a completely different set of circumstances that were leading up to similar data protection laws. The Swedish government started using computers way before a lot of other countries. They had a really small population, they had really high standards of living and income, and they could kind of foresee the usefulness of automation that computers would provide. Sweden at the time was called a paradise for registers. They had vast amounts of information about its citizens. So it was said that the average adult would appear in 100 separate data systems, 200 if you were married, and that might not seem like much to us, but you might have like 100 apps on your smartphone. But this was the 1970s, so that was a lot. There was already kind of this notion of a strong notion of the right of public access based into the Swedish constitution. And this generally meant that the public could be present at court hearings. And in 1949, the Swedish government also passed the right of the press to government information. So this meant that the press and the public had access to public records. This is great. If you're a journalist, you are working on a lead, you can go down to the city hall, pull some files on the person that you're interested in, and they'll make you a copy. But once you combine this with computers, private entities would gain the ability to gain vast amounts of information about its citizens with very little effort. So in 1973, Sweden got the Swedish Data Act. This was the first national data protection act. It had 3 tenets. 1, you had the right to get data about yourself. 2, you had the right to compensation if the data was incorrect. They were really concerned about data being wrong. And 3, it criminalized data intrusion. This is formally criminalized, and this law meant it was specifically focused on breaking into the offices where the data was stored. Kind of like this. The Swedes were smart, but they couldn't actually predict that the internet was going to be a thing. So back in Germany, the Hessian law was enacted, and other states were trying to work on similar laws. And based on Sweden, they determined that they needed a national law as well. So in 1977, the German Federal Data Protection Act was passed. And it had 3 parts. It ensured against the misuse of data, it prevented harm to personal interests, and it prohibits the processing of data without being specifically permitted. So it actually created a regulating body that gave out permits for people to do data processing. You can't just collect it and then decide what you want to do with it later. You have to go and get approval every time. Over in the UK, people kind of wanted similar laws. And after much reluctance and dragging of feet, the UK government eventually passed the UK Data Protection Act. We kind of think of the UK as sort of being a nanny state. They didn't really want to pass this law. In fact, one early commission actually found that there was no evidence to suggest that fears about the improper use of computers in the public sector are justified by current practice. They're like, yeah, data protection is not a problem. So this law was widely criticized, wasn't very effective. But in 1985, the UK joined the European Communities, which is a precursor to the European Union. And the European Union was working on its own policies. Like, look how optimistic that flag looks. In 1995, they passed the EU Data Protection Directive. And generally, this laid out a baseline respect for privacy, right? More specifically, it had 7 key recommendations. First is notice. You should tell data subjects when their data is being collected. 2, the data should only be used for the purposes stated and not for anything else. 3, data should not be disclosed without the data subject's consent. 4, the collected data should be held securely and from any potential abuses. 5, data subjects should be informed as to who is collecting their data. They should have the right to access the data and make corrections to it if they want to. And they should have a method available to them to hold the people collecting their data responsible in case anything else goes wrong in the previous principles. So this was really awesome, except it's a directive, which means that it's non-binding. It's just a suggestion or a recommendation, and it's not actually law. So no one really did anything at all. All right, so we're like in the late 90s right now. Do you notice anyone missing from this story? How about this country? Can anyone name the major national data protection law that we have here in the US? I gave this talk once before, and someone shouted out, the Patriot Act. And I know we have some Canadians in the audience, so the Patriot Act is this authorization of massive wiretapping and metadata gathering program by the US government. So it's pretty much the exact opposite of a national data protection law. You might say the Fourth Amendment. Fourth Amendment protects us from unreasonable search and seizure. And in fact, the closest we've become to challenging the Patriot Act is in Clayman versus Obama, where a district court ruled that it probably violated the Fourth Amendment. However, in ALCU versus Clapper, it was determined that the global telephone data gathering system is needed to prevent potential terrorist attacks. It can only work if everyone's data is included, and that Congress legally set up this program, and that it does not violate anyone's constitutional rights. So even wiretapping every single US citizen doesn't constitute unreasonable search and seizure. So yeah, we don't really have a national data protection law. But we do have the Video Rental Protection Act of 1988. This prevents the wrongful disclosure of videotape rental or sale records. I'm sure you're all really concerned about this. So that's cool. And so don't get me wrong, we actually have a whole lot of laws like this. So all of these address like a very specific small part of data protection. Like HIPAA, you've probably heard of, it's just for health records. Fair credit reporting, it just allows you to update and make changes to your credit report history. CAN-SPAM is just about the collection of email addresses. So these are all like tiny steps in the right direction, very tiny steps. But more recently, we took a big step in the wrong direction. Somebody signed this into law, Senate Joint Resolution 34. And what it did was this. It basically reversed the law that prevented ISPs from selling your browsing history. So this is now legal. And you might say, everything is terrible here. I'm moving to Sweden, right? So yeah, maybe that's true if you live in the US. But if you live in the EU, you just got the EU General Data Protection Regulation, or GDPR for short. The scope of this is incredibly broad. It applies if the data controller, data processor, or data subject is based in the EU. So if you're an American company and you have one customer in the EU, you have to comply with this. It's a single set of rules shared amongst all the member states in the EU, and it has a couple kind of key points. The most well-known is probably the right of erasure, or the right to be forgotten. This means that you can go and get your company to delete your data. There's also the right of access, get a copy of your data. So this leads to really fun and interesting things where reporters go and call up Tinder and they get their mind blown when they find out that tech companies are actually storing every single piece of information about you. This journalist asks, like, what if my data is hacked or sold? And so yeah, what if it is hacked or sold? So the law carves out space for data breaches. A data breach has to be reported within 72 hours. 72 hours. Not 5 weeks. Not 1 year. 72 hours. It also outlines the right to compensation. So if there has been a breach, the person that has suffered the damage has the right to receive compensation. And this is actually amazing for the EU because in the EU, they don't have anything like a class action lawsuit like we have here in the US. So this is actually a way for consumers to get monetary value from companies. Also, pseudonymization. The resulting data cannot be attributed to a specific person. So this is basically use encryption on your data, please. And consent. Data collectors must be explicit about what is being gathered and what it's being used for. It also sets up a person at every company called the data protection officer. This person has expert knowledge of data protection law, and they work with the commissioners to figure out if their company is in compliance or not. And the best part about the GDPR is that it is binding. There is a warning in the first cases for non-intentional non-compliance. There's also regular audits, and then there's also fines. So the upper fine is as much as 20 million euros, or 4% of annual worldwide revenue, whichever is greater for the first offense. So put that in scale. Apple made $229 billion last year. A single fine would be $9 billion for them. That's huge. And this went into law May 25th, 2018. All right, so the last time I gave this talk, it hadn't gone into effect yet, so I made some predictions, and I thought it'd be interesting to revisit those. So the first prediction I made was that GDPR compliance is going to be a big deal. And yeah, it's a big deal. You can kind of tell how big of a deal something is, how much a moneymaker it is, by how many ads show up when you search for it. Second prediction I made was that someone is going to get sanctioned. So like, what good is a law that you don't actually enforce, right? And that's exactly what happened. So in October of last year, a small business, this was the first time GDPR was enacted, small business had a camera set up outside their business, and it was recording too much of the sidewalk. And so they got fined under the GDPR. This was in Austria, because they weren't asking consent for the people that were being recorded. In November, there was a German chat site. It reported a data breach to the local protection agency. They investigated, and they found out that they had been storing their user passwords in plain text. They were fined 20,000 euros for data storage practices, not because of the breach, right? They did everything right. You don't get fined for having a breach, or as long as you report it correctly. This was the next one. A Portuguese hospital got fined 400,000 euros because they were using bogus accounts to access patient records. This is great. And most recently, this little software company that you might not have heard of, they got fined 50 million euros for not sufficiently informing users whether advertising data was being collected and how it was personalized. So I was a little more correct on that than I probably would have liked to have been. The third thing I predicted was that don't expect anything to get better in the US in like the next 2 years or so. And I said that you probably should expect further dismantling of privacy laws and regulation. I was totally wrong here. So recently in California, the great nation of California, they passed the California, the California Consumer Protection Act. And so this is for any for-profit entity that does business in California, makes more than $25 million, and either processes the data of a lot of people, earns its money from processing data, or has a bunch of data about its users. They can be fined for data breaches, for intentional violations of this. And this is great. This is going to go to law in 2020, January 1st, 2020. And even more recently, there were some bills introduced to the Senate to introduce federal data protection laws. So this is one of 2 bills currently referred to the Senate Committee on Commerce, Science, and Transportation. And yeah, we're actually kind of working on creating a national law. So yeah, maybe everything is not so terrible after all. All right, one last thing. We live in an age where we have the ability to generate so much data about ourselves, and the capacity for others to collect it is enormous. So it might not come as a surprise to anyone in this room that Tinder has so much data on its users, for example. But for the majority of Tinder users, they simply don't know, or they may not realize this. We need to make sure that on their behalf, and for our own sake, that this data is being protected, it's being used responsibly, and that it will not and cannot endanger the people from which it is taken. Thanks.